Let's begin by looking at how private land can be controlled. We discussed nuisance claims in our first lecture under the topic of common law. It involves a legal process to stop someone from using his or her property in a way that negatively affects you, for example, noise, light, smell, or pollution. Easements are another option for you to control land. You can create a conservation easement that restricts actions on your land, like cutting down trees, to preserve the land. The Nature Conservancy uses conservation easements to buy and preserve large tracts of land. If the owner sells the land, the conservation easement runs with the property's title in perpetuity. Covenants are popular with suburban communities. A town like Reston, Virginia uses covenants implemented and enforced by a homeowners association. The homeowners association can restrict certain actions, mainly cosmetic, on a person's property. When you buy the house or dwelling, you sign an agreement stating you'll comply with all covenants. Income tax provisions are a means of privately controlling land. For example, the tax law may provide a financial incentive to donate your land to a charity that then subdivides it into smaller parcels for the tax benefit. Let's shift to public land use controls. One obvious public land use control are federal programs, specifically the environmental laws we've discussed in this course. Think about how the Clean Water Act wetland permits restrict land development by prohibiting the filling of eligible wetlands, which was the problem in New Orleans during Hurricane Katrina. At the state and local level, the police powers provide the authority to pass zoning regulations. This authority comes under the constitutional right of police power. Zoning began in the 17th century to prevent fires by requiring buildings to be made of certain material, but over time zoning gradually expanded to include building heights and location for public safety. In the environmental protection area, zoning has been used to preserve open space, protect wetlands, and preserve areas for aesthetic and historical value. The question I'd like to pose is, are all these legitimate uses of the police power? The answer is yes and no. Courts have given states and localities great latitude when it comes to zoning that protects public health and safety. When the police power of zoning does not advance a legitimate state interest, the courts have overturned the zoning action. In cases where zoning eliminates all economically viable use of the land, then this is considered a taking, thus requiring compensation. One issue is when zoning crosses the line into an illegitimate state purpose. To guard against this, there are two things a legislature can do. First, it can base this decision on a master zoning plan that goes through an open public comment and review process. The open, transparent, and well-designed master zoning plan usually insulates the action from judicial challenge. The second thing the legislature can do is to ensure that the zoning promotes a valid public purpose and does not go beyond this valid public purpose. Then there's regulatory taking as an eminent domain. The concept of taking land for a public purpose and compensating the owner for the land is enshrined in our Constitution in the Fifth Amendment. In our early history, eminent domain was used in cases of physical invasion of property, such as the building of a dam. In our modern era, the concept of takings was expanded to include not just a physical taking, but an economic one. If the value of the property was destroyed, that is, nothing of value remained, then this would constitute a taking, thus requiring compensation. Read over the facts of this case from 1922. The issue of this case comes down to whether or not the state's law was a legitimate use of its police powers. The court decided that in this case, the state had gone too far. There is no longer any economic value left to the company's property. In this case, the property had been taken and compensation is owed. Some 65 years later, a similar case arises in the same area, except the state law only required that 50% of the coal in the developed area be left unmined to support the surface. So in this case, did the state go too far? According to the court, it didn't. The law is valid because it didn't deprive the owner of all economic uses. Our first case is the landmark case of Penn Central Transportation Company versus City of New York. It's a landmark case because it establishes many of the principles of takings law that exist today. In the absence of legislation that clarifies what constitutes a taking, this case establishes the common law understanding of takings. The image to keep in mind is that property rights include a bundle of rights, and in this case, the air rights. That is, the right to build above the building is just one of many other rights. While the air rights may be infringed upon economically, the other property rights are still intact. In our second case, Loretto versus Teleprompter Manhattan from 1982, this case involves the issue of a physical occupation of the property by the state. As you read through the takings cases, picture a spectrum of takings, where on the left end there's a permanent physical occupation, which is considered a categorical taking, as in this case. We'll cover some items that should not be considered a taking in a moment. Continuing with the image of the bundle of property rights which accrue to any property owner, such rights are sacred under U.S. law. When a physical invasion occurs, it cuts across all these rights, and the extent of the invasion, however minor, is immaterial to the loss of this right. Our next case is Lucas versus South Carolina Coastal Council. In this case from 1992, the court reaches an important milestone in the consideration of when a regulation impacting property has gone too far. This case tests the limits of the use of a legitimate state purpose as a means to avoid a taking. This case reinforces the two possible categorical takings, meaning if any of these two are present, it's a taking that requires compensation. Over on the other side, this case returns the concept of a legitimate state interest to its original construction of requiring a noxious or odious common law characteristic. The next concept and case deals with regulatory exactions. This is a quid pro quo situation. We, the state, will grant you this zoning exemption or privilege if you do something for the state or public. The key in these situations involves nexus and proportionality, terms we'll explore in the next case. In Nolan, this case deals with an improper regulatory exaction. There lacked a nexus between what the state desired and what it made the homeowner do. I should note that this case predates the Lucas versus South Carolina case, so there are elements in the Nolan case that are no longer relevant because of the Lucas decision. The legal theory of regulatory exaction was amended in the Dolan case. In this case, a building owner wanted to expand its store and pave over its gravel parking lot, and the city conditioned the building permit on the owner preserving a small percentage of the property as green space, but also building a bike pathway. In this case, was there a Nolan essential nexus between the legitimate state interest in preventing flooding and then the requirement to build a bike or pathway? The court found that there actually was a nexus, but it found that the bicycle path was not sufficiently proportionate to the city's concern over construction in the floodplain. Regulatory takings law has narrowed over the past few years. In Penn Central, the court said to examine the government action by balancing economic value with the state's legitimate interests, but more recent cases have focused on the severity of the burden. In fact, the Lucas decision found that focusing on the state's interest tells us very little about the regulation's impact or character. By 2005, in Lingell, the court rejects as a valid reason for a taking the claim of a legitimate state interest.